Hi guys, this is the second lecture for chapter 3. So in the first lecture, we talked about the Fourth Amendment and we talked about what was expressly protected by the Fourth Amendment. Remember, 4 things: persons, house, papers, effects. Okay, so drill those in your head. If it's persons, house, papers, effects, they automatically get Fourth Amendment protection. And then we said how that definition was expanded by the Supreme Court with the expectation of privacy test. So we now know that persons, houses, papers, effects are protected. And then we know besides that, anything that meets the expectation of privacy test is also protected by the Fourth Amendment. So that was our first step. Is it even covered by the Fourth Amendment? So we know it has to have governmental action, and we know it has to be something that's actually protected by the Constitution. So today what we're going to talk about is it has to be a search. It's only protected by the Fourth Amendment if it is in fact a search. So that's what we're going to talk about today. How do you define search? So I'm going to share my PowerPoint and we'll talk about that. So we talked about what is protected and then now defining search and seizures, because it only protects against unreasonable searches and seizures. So we have to define search and seizure. Okay. So once we decide that it is protected, then the Fourth Amendment will kick in. So our first step was deciding, is there governmental action and was it protected? As long as there's governmental action and it is protected, then the Fourth Amendment kicks in. When the Fourth Amendment kicks in, then we have to start what's called the Fourth Amendment analysis. The Fourth Amendment analysis has 3 steps. First was the law enforcement action, a search or seizure under the Fourth Amendment. So that's what we were just saying. We have to define what is a search and seizure so we know if it is actually a search and seizure defined by the Fourth Amendment. The second part is, if it is a search and seizure, is it reasonable? So once we decide it's a protected area, we decide it's a search, then we have to decide if it's a reasonable search, because remember, the Fourth Amendment only protects against unreasonable searches and seizures. So we'll talk about that unreasonable part next week. And then remember, if it is unreasonable, if you decide it is a search and it is unreasonable in an area that's protected, then the exclusionary rule kicks in. So all that stuff we learned last week about the exclusionary rule, that will kick in, and the evidence would be excluded from trial, or any fruit of the poisonous tree of the search would also be excluded. So luckily, we've already done the bottom part. So the last part of the analysis, we've already covered last week with chapter 10 when we talked about the exclusionary rule. So you already understand that and the exceptions to the exclusionary rule. So now we have to go back and we're going to start with the first question. So we already said if it's governmental action and there's a protected area, then the Fourth Amendment kicks in, but it only protects against things that are defined as search and seizure. So we're going to define what that means. So there are some basic definitions. Basically, a search is any intrusion by the police, by the government, into an area that a person would expect to be private for the purpose of looking for evidence to use in a criminal prosecution. Okay, so we already talked a lot about this definition. It's an intrusion or a looking in a place that a person would expect to be private. So either one of the 4 expressly protected areas, persons, house, papers, effects, or another area that the court would have deemed that a reasonable person would expect to be private. And the reason why the government is looking in those places is that they're trying to find evidence to prosecute the person. So that is the definition of a search. Now, if you read the Fourth Amendment, they use the word seizure, and they actually are referring to seizing property or seizing persons. I'm only going to use it in this context as seizing a property. So first they look for it and then they seize it. When I'm talking about seizing persons, I'm going to use the word arrest just to keep them distinct from each other in your mind. So we're talking about searches and then seizing of certain property after you do the search. And a seizure of property is when you interfere with that person's ability to possess or have an interest in that property. So seizing means I'm taking it, I'm confiscating it, I'm doing something with it, and it's keeping you from being able to use the property like you want. So if I conduct a search and I take property, I turn it into the evidence room at the police station, you can no longer use that property. That's a seizure of property. So what about this? Is it a search if police attach a tracking device to your vehicle and track your movements? So we know that they can walk around and follow you because we talked about that in the last class. That's not protected. Anywhere that you walk, they can walk and follow you if they want to. But this is different. This is actually taking a GPS tracker and putting it on your car and having to track you through that GPS attached to your car. Would that qualify as a search? So remember, this is the lecture where we're defining searches. So if the Supreme Court says this is a search, then it could be found to be in violation of the Fourth Amendment. If the court said it's not a search, we don't count this as a search, then it does not receive Fourth Amendment protections. So this went to the Supreme Court in a case called U.S. versus Jones. And in U.S. versus Jones, the government did attach a GPS tracking device to a vehicle and they monitored the person's movements. And it basically told them that they went to a certain place that was connected to the crime. So then they wanted to use that evidence against him. And the Supreme Court said, yes, it is a search. Now, remember in Olmstead, the first case we talked about when we talked about conversations on the phone and whether those were protected. And we said in Olmstead, the court said they're not protected because there's no physical intrusion into a telephone conversation. You're just listening. Whereas Katz, you were actually attaching something outside. So U.S. versus Jones was equivalent to a trespass. Because remember, they are actually physically trespassing on your car by putting a tracking device, a GPS on it. Since they're actually attaching something to your car and they're trespassing into your car or onto your car, that is considered a search. So remember, governmental action, yes, the government is the one that attached it. Is it an area you expect to be private? Yes, your car and where you go in your car is private. And unless you're doing it in the open, they have to track you with a GPS. That is private. By attaching the GPS to the car, that is a search. So this is one of those places where the court said it is a search and you should have gotten a warrant for this search. So what if police use satellite-based monitoring for a convicted sex offender to track his movement? So this is like a ankle bracelet. So a man is put in jail for sex offenses. They release him early on parole, but they want to put an ankle monitor on him. Is that a search? By attaching the GPS monitor to his foot, does that constitute a search? And some of you are like, well, he violated the law. Absolutely, they can do that. Remember, that's not what I'm asking, whether they can do it or not. I'm asking whether the Supreme Court would declare that a search under the Fourth Amendment. So again, governmental action, yes, they're the ones requiring him to wear the ankle monitor. Is it an area that's protected? Yes, it's your body and where you go. It is a protected area. Now, the next question is it a search? Not whether they think you can do it or not. It's whether or not it's a search, okay? If they say it's a search, then it's still going to be okay as long as they deem that you did the search reasonable. We're not on the reasonable question yet. We're just simply trying to decide if the court would say it was in fact a search. So this came up in Grady versus North Carolina, and the Supreme Court said it is a search. So attaching a GPS monitor to somebody, an ankle monitor to somebody, is considered a search. It doesn't mean they can't do it as long as the court says it's reasonable. So remember that part we haven't gotten to yet is even if it's a search, it's still okay as long as it's a reasonable search, because the Fourth Amendment is only protecting against unreasonable searches and seizures. Okay. So the court in this case said it is a search. It does qualify as a search. They did not answer the question of whether or not it was reasonable. Can the government use sensory enhancement, such as thermoimaging devices, to detect invisible infrared radiation coming from your home? So this was a case where the police wanted to drive in front of a house, and they used like a thermal imaging to see if anybody was in the house. They thought that they were selling, growing drugs in the house. So they had a lot of heat coming out of the house from the lamps they were using to grow the plants. So they used this infrared on the house to be able to track who was in the house and what was in the house. And the Supreme Court had to decide, is that a search? Is using infrared. So they're not entering, they're not really trespassing in the house. They're just using this outside the house. Does that qualify as a search? And the Supreme Court said, yes, it is a search. Number one, it is a protected area. It's your home. So it's an expressly protected area under the Constitution. I guess number one is really there is governmental action. The government's doing it. Number two, it is a protected area. It's your home. And then the third question is, was it a search? And the Supreme Court said yes. What they said is, since you have an expectation of privacy in your own home, they cannot use special devices that enhance your senses to be able to see things that a normal everyday person would not see, okay? So anything the general public would not have access to, you cannot use those things to enhance the senses that you would have, okay? So if you couldn't see through the walls normally, then you can't use a special device to see through the walls, or that qualifies as a search, okay? So police can see and hear things that any member of the public may see and hear only without fear of the Fourth Amendment regulation. Only when they see and hear things that members of the public would not be allowed to see and hear has a search taken place. Okay, so think about what we just learned. Did that thermal imaging device give the police an advantage to see and hear things that a normal person wouldn't? And the answer is yes. And since it does, therefore it qualifies as a search. Okay, but what about this? Can police use an 800-meter telescope with a 60-millimeter opening to observe activities from someone inside a building? So that is the strength that would allow you to read something that the person was holding from a quarter mile away. So think back, is that allowing the police to see and hear things that a normal person would not see and hear? The answer is yes. So that is a search, okay? Can they fly a plane over your land and see what's in your fence? So do normal people have the ability to fly and see down into somebody's yard? Yes. So that would not be considered a search, because average everyday people fly every day and they can look down and they can see what's inside your fence. Can they hire a plane to take you over and take photographs? Still, yes. An average everyday person could fly over, look down, and take photographs. People fly all the time. So the second two would be okay, because those are things normal everyday people can do. But the first one is using a sensory enhancement that most normal people would not have access to. So that is a search. What about drug sniffing dogs? Are they searches under the Fourth Amendment? So if you have a dog sniffing, is that giving the police advantage to see and hear and smell things that a normal person would not see, hear, or smell? The Supreme Court decided this issue in U.S. versus Place. So the question is it analogous or distinguishable from Kylo? So Kylo was using an infrared to see through walls. A dog is using its senses, its smell, to smell things that an average human could not smell. So in a way, it is enhancing your senses, right? So it is very similar to Kylo. I think it's distinguishable in the sense that it's an animal, though, and so it might be treated different. The Supreme Court said that it is not per se a search. So that means it's not automatically considered a search. you have to look at lots of factors. Where was the dog when they smelled? What were they doing? Where were they located? All of those things. So you're going to have to consider all of those things if you want to know if it violates the Fourth Amendment. But we're not going to say a dog sniff is automatically a violation of the Fourth Amendment. Okay, so what about this? Florida versus Jardine. In this case, they walked the dog up onto the person's porch and had him sniff around the front door. So how is that similar to place? How is it analogous? Well, it's a dog sniffing. So we're using the senses of a dog that we wouldn't normally have access to. How is it distinguishable? In place, they were in a public place with that anybody could go around. But in Jardine, they were walking on a porch on a house. So that is a place that is expressly protected by the Constitution, the house and the curtilage. Since it is already expressly protected, the court said it is a search then. Since they are on the curtilage, then therefore it makes it a search. So remember, in the place case, they said it's a case-by-case determination. In that one, if you're in a public place, you're getting on an airport and the dogs walk around, you're out at a park and the dog walks around, that's okay. But if they're going into a place that already has some extra protection, like a home, your curtilage, the courts are going to determine that those are searches. So you have governmental action because the governmental dog, it is a place that's expressly protected on your curtilage, and it is a search. So we meet all three parts of that analysis. So how do we determine if if this sensory enhancement is permitted or not permitted? Well, the court will look at lots of factors. So when the police are trying to use technology or dogs or whatever it is to gather evidence to search, the court has to consider lots of factors. Sorry, it's so rude. To determine if it's a sensory enhancement device. So the first thing is, where is the place that's being surveyed? So we already said if you're out in public, it doesn't count. But if it's on a place that already receives protection, it is going to be a sensory enhancement, which is a search. What's the nature of the activity that you're surveilling? If people are just walking around in public, you can do it. But if they're trying to keep their activities private, and they're private activities, then you can't. Care taken to ensure privacy. What was the person doing trying to keep it private? If they're taking some extraordinary steps to try to keep it private, then it's more likely the court is going to declare it a search. Can you see it from a lawful vantage point? Are you where you're allowed to be when you see it? So if you're just standing on the sidewalk and you can see it, then you're in a legal vantage point. But if you have to walk somewhere or be somewhere that you don't have the legal authority to be, then that's going to probably be a violation. The availability of the technology, is it highly sophisticated technology that the average person wouldn't have access to? Probably not going to be allowed, okay? And to the extent which the technology enhances or replaces natural senses, is it completely taking over from your natural senses that a normal person without this could never see, hear, smell this stuff? Or is it something that's just enhancing it a little bit? So it's a total circumstances test. The court is going to look at each of these factors and have to make the determination if it is sensory enhancement or not. If it is, it may be a search. If not, it's probably not a search. So what if police are just walking down the street and see illegal contraband? And they do they have to get a warrant to seize it? Police walking down the street and you're carrying an illegal gun and they see it. Well, they don't know if I guess it's illegal, but that you're carrying a gun and they don't think that you should have it. And it's just out in the open, you're just carrying it in your hand. Do they have to get a warrant before they can look at and see and seize the gun? So that is one of the questions. They're just out in the open. Now, this comes up with the concept of what we call plain view. And plain view is the word, your key word for this lecture. So plain view is the idea that if something is in plain view, then they don't have to necessarily have a warrant. So make sure you write that down as your key word for this week, plain view. So if police can just see it and it's out in the open, then it is not considered a search necessarily, okay? Because it was just there. They didn't have to search for it. It was just there. Now, plain view, there's two types. There's what's called a search-related plain view and a non-search-related plain view. And each of them have a little bit different rules. So let's look at each of these and how they work. So, I guess I have to explain first. So a search-related plain view is when you are legally searching for one thing and you happen to find something else, okay? So I have a warrant to search your medicine cabinet for Oxycontin, illegal Oxycontin. And when I'm searching in there, I also find heroin. So I'm legally allowed to do the first search and I happen to see in plain view other things. That's going to be okay. They're going to allow that. A non-search related is when they're not looking for anything. They just happen to see it out of the corner of their eye or wherever. That is non-search related. They're not actually looking. So let's practice search related or not search related. So an officer sees a woman take a joint out of her purse in a restaurant. Were they actually searching for something or is it just out in plain view? So non-search. That's non-search. Officer at a stoplight sees a man take a sawed-off shotgun and hand it to the passenger. Search related or non-search related? That is non-search related. Okay. Officers have a warrant to find a joint in the woman's purse and they find something else. That's search related. Okay. So those are the distinctions between them. Now we need to look at the rules for each one of these. So if it is non-search related, if police just happen to see it, they aren't looking for anything, it just happens to be out in the open, that's non-search related. And in order for it to be legally used against the person, you have to meet two requirements. Number one, the officer has to legally be where they're at when they see it. So if it's on curtilage or something and the police officer didn't have the right to be there, then they cannot use that evidence. It would be excluded. So the number one thing is that the officer has to be legally where they're at when they see it for plain view to kick in. And then the last standard is what we talked about. You can't use any enhanced sensory devices. So if you have advanced technology that allows you to see and hear things that a normal person wouldn't, then that is a search. It's not considered non-search related. So if you do, then you have to make sure it's a reasonable search. So for non-search, you have to legally be where it is and you cannot use any enhancement devices. You just happen to see it. So if it's considered a non-search related plain view, it gets no Fourth Amendment protection whatsoever. So there's no governmental action. It goes back to that very first question, is there governmental action? If police are just walking down the street and happen to see something, there's no governmental action, they just see it. So non-search related plain view does not even involve the Fourth Amendment. You automatically just say, nope, non-search related is plain view. It doesn't even get Fourth Amendment protections at all. So let's switch to search related plain view. So when we're talking about search-related plain view, remember, we have a warrant to search for one thing, and we happen to just find something else. And the Supreme Court created the test for plain view, search-related plain view in Harris versus U.S. And what the Supreme Court said that if you are legally where you are allowed to be, and you're looking for one thing, and there's evidence that's just out in plain view, just there where you're looking, legally looking, and it's immediately apparent to you that it is evidence of a crime or part of a crime, then you can seize it, okay? So this is when you're looking for evidence and you know you have the right to be there in the first place. You have the right to be searching in the first place. You see something else that's just out there, and by looking at it, you immediately know that it's evidence of a crime. Then search, that's plain view exception rule. And you still can use it against the person at trial, but only if you meet all three parts of the test. So officers are searching for one item and see something suspicious not on the warrant, but they cannot immediately tell if it was illegal without moving it. So this was Arizona versus Hicks. So the police receive a telephone call that there was a shot through their cart floor and a bullet came through their floor into their apartment. So police immediately respond and go to the apartment below. They ring the doorbell, nobody answers. So they go in, which they can, which we'll talk about next week when we talk about exceptions to warrants. When they're in there, they see TVs along all of the walls. And they know that a TV electronics store was recently robbed and a bunch of TVs were taken. So they see all these TVs. So they're instantly thinking, okay, these are the TVs from that store. But they didn't know. They had to actually move each TV and look at it to read the serial numbers and then call it in and see if they were in fact the TVs. So the court had to decide, does this qualify as search plain view, search related plain view? And the Supreme Court in this case said it is unconstitutional because it was not immediately apparent that the TVs were contraband without moving them or manipulating them in some ways. So you cannot move or manipulate any items at all. You have to just be able to look at it and say, yep, that's evidence of a crime. You can't question it or anything. So you legally have to be where you are. You're looking for one thing and you have to immediately know from looking at it that it's something illegal to possess or that you can confiscate without moving, manipulating, touching, or doing anything. Okay, so those are the rules now for search and seizure. Now we're going to take that information and we're going to start using it in analysis. So remember our last analysis, we were taking the information on protected area. So we were saying, is it governmental action? Is it an expressly protected area? Is it an area that a reasonable person would expect to be private? So that was the first part of our analysis. But now we said we have to go to the next step. Is it a search? So you will see this posted. I created the search and seizure flow chart, and it is posted under the weekly materials. I would strongly, strongly recommend that you print it out and have it with you. It is going to be very helpful on your homework and on your exams. This gives a step-by-step analysis that you should follow when answering any questions about search and seizure. So if we start at the top, our flow charts, we always start at the top. Is there governmental action? Remember, if there's no governmental action, automatically not protected. If there is governmental action, our next box is the area protected by the Fourth Amendment, or is there an expectation of privacy? So the next question you have to answer, is it one of the 4 expressly protected areas in the Constitution, or would it be something that the Supreme Court said a reasonable person would expect to be private? If we decide it's not something private, we're done. We're done with the analysis, no Fourth Amendment protection. If we decide it is something that would be protected, then we go down to the next box. Is it defined as a search under the Fourth Amendment? So then we use what we just learned to make that assessment. So this is the only part that we're actually using right now. We will finish the bottom half next week. But for this week, these are the only questions I want you to answer. I don't want you to go any further. I don't want you to say, is it constitutional or not? I simply want you to decide, is there governmental action? Is it an area protected by the Fourth Amendment or expectation of privacy test? And then is it a search as defined by the Fourth Amendment? Okay, so let's put one together. Brad's neighbors, the busybodies, suspect he is counterfeiting money. They speak to the police and the police tell them to get evidence. Late one night, they break into his home and search his basement. They find illegal equipment and several thousand bills with no serial numbers. They seize the money and take it to the police. Brad is charged with felony or federal counterfeiting offenses. He claims that the evidence should be excluded because his Fourth Amendment rights were violated. So remember, you work for Brad. You are Brad's defense attorneys. You need to make an argument that the search was in a protected area and was a search using the IRAC method. So remember, we're going to always use IRAC. So issue, rule, analysis, conclusion. So we're going to start with our flow chart. Okay, our flow chart, this part is going to be our analysis. So we're going to answer these questions in the analysis portion of the IRAC. Okay, so first we need to start with the beginning of IRAC. So the first one is our introduction. Oh, sorry. This is the same thing. This analysis, these are the questions you're going to answer in the analysis section. So our first thing is our introduction. So remember, it's just a statement of what our findings are going to be. So busybodies' actions were governmental action and they did qualify as a search in a protected area. Okay. Now we're going to identify the precedent that we're using to make this decision. So we're using the Fourth Amendment and we're going to use the Bordeaux case, Bordeaux versus McDowell. Remember, Bordeaux said that it's only governmental action if the government encouraged you or got you to engage in the action. So Bordeaux versus McDowell goes to that very first question, was there governmental action? And it says no private citizen can turn over information, or private citizens can turn something over as long as they were not an agent of the police. And then the next part is our analysis. So this is where we're going to use this analysis section. We're going to answer each of these questions. So you need the flow chart to answer the analysis. So busybodies were agents of police under Bordeaux. Police told them to get the evidence. Since they were agents, there was governmental action. Was it a protected area? Was the home? Yes, the home is considered an expressly protected area by the Constitution. They had to look around, so therefore it was a search. So you use the analysis section to go through governmental action, protected area. Was it a search? Therefore, it was a governmental search in a protected area. So we answered each of the questions. Now, notice I didn't say whether it was reasonable, whether it was unconstitutional. I didn't say whether the evidence would be excluded. I'm not there yet. All I'm asking is there governmental action? Is it a protected area? And is it defined as a search according to our constitutional definition? Okay. So what I want you to do is I want you to try to do this one on your own. Kevin and Rachel, college sophomores, were casually dating for the month. One night on a frat party, things got out of hand. The next morning, Rachel's mom called the police to report that her daughter was date raped. Police interviewed Rachel and convinced her to call Kevin and discuss the events in a hope that Kevin would admit to the rape. Police coached Rachel regarding what to say. And 10 minutes into the conversation, Kevin admitted to Rachel that he had sex with her without her consent. Unbeknownst to Kevin, the conversation was recorded by police with Rachel's permission. It is a two-party consent state. He claims the Fourth Amendment was violated and the conversation should be excluded. So we are going to use IRAC. And we are trying to determine, is this a search according to the Fourth Amendment? So we want to start out, and then we're going to use all those questions for the analysis. So we're going to use our flowchart, and this is going to be for our analysis. So we can quickly do it in our head and come up with our conclusion. And then we're going to use this in more detail as we get to that section. So we're going to start with taping conversations was a search in the Fourth Amendment protected area. So our introduction is actually like a conclusion. We're saying, yes, it is protected. And then the precedent, the rules we're going to use. So always the Fourth Amendment on a search and seizure. So Fourth Amendment will be one of our rules. And then US versus white. People don't meet the expectation of privacy test with conversations because a reasonable person would feel or assume that the other person disclosed their conversation. So you might think, well, it's not protected because one person says it wasn't protected, another person says it is protected. Okay. And that's my train of thought. I lost my train of thought. Okay, so Fourth Amendment. So US versus white. So people do not have an expectation of privacy in a conversation as long as one person agreed to the conversation. So that's US versus white, okay? So remember false friends, as long as one person agreed. But remember, in this case, we are a two-party consent state. That means both parties had to consent in this state. So that gave more protection than the Supreme Court. So we start at the beginning of the analysis. In this scenario, the evidence would not be permitted at trial. First, there is governmental action. So we start at the top. There is governmental action. She was directed by the police to record the conversation, and that makes her an agent under Bordeaux. The Fourth Amendment telephone conversations are generally not protected under the Fourth Amendment. So remember, under conversations, under white, we said conversations do not receive an expectation of privacy. There's always a chance somebody could record it. But since this is a two-party consent state, therefore it is going to be protected because this state specifically gives more rights than the federal government. Since Kevin did not consent, then you did not have two parties consent, and therefore it is an illegal search, and the evidence is a search of a protected area. Okay, so hopefully that helps you with IRAC. Now, I have multiple more problems. These are things you really need to look at. So go online and look up the Fourth Amendment practice problems and try to answer them using this analysis. So write out or just jot down, not going to collect, but just jot down what you think the answers are, and then look at the key and make sure you're on the right track, okay? So these are the problems. Janie is sitting on a bus talking loudly on her cell phone. An undercover officer hears her stating that she robbed an old lady, a social security check. The police officer arrests her. So using IRAC, how would you just do that? Remember, you're always representing the defense. Police install a peephole in the ceiling of a restroom so they can observe what people are doing in the restroom stalls. They witness two people engaging in sexual activities in the bathroom stall, so they are arrested. Is that a search? Two officers were on patrol in an apartment complex when they heard loud voices coming from the first floor. The officers approached and looked through the window. They saw two men screaming and shouting and poking at one another. They rushed to the front door and arrested the men for disorderly conduct. When making the arrest, they noticed cocaine on the nearby table. Is that a search of a protected area? And then I'm just going to let you read the rest. So there's 4, 5, 6, 7, 8, 9. So try to, you don't have to do detailed sentences, but just kind of try to jot down your answer, what you think they are, and then look at the key. Oh, sorry, there's even 10, and see how you did. Okay, so it's really important you try these because you may think you understand. A lot of times people think they get it. Oh, I get this. And then they go to do a homework and they're really confused. So it's really important that you try a couple of these on your own and make sure that you get them. Once you feel comfortable with it, then you're ready to finish the second part of Chapter 3 assignments. So remember, the first part was just protected area. Are these even protected? Then the second part of that assignment is going to be taking it the next step. Is it a search? Does it qualify as a search? So I hope that that makes sense to everyone. If you have any questions, please reach out. I'll be more than happy to answer them. I know it gets kind of confusing with all the precedents and everything that's going on. So definitely reach out if you have any questions on anything. And I will talk to you soon. I'll talk to you next week when we move on to Chapter 6. Remember, we're not in order. We go from 3 to 6. So next week will be 6. Okay, so I will see you all later. Bye.